This presentation is about defamation, in particular, two Supreme Court cases, Sullivan versus New York Times and Gertz versus Welch. Sullivan versus the New York Times. Libel is the written form of defamation. Sullivan claimed that the statements made in the ad were defamatory per se. One of the three statements for filing this claim is that the statement used shows the person is incompetent in his job. This is the reason that the defamatory per se claim was used, because Sullivan said that the false statements reflected upon his position as commissioner in charge of the police. Another element for a defamatory statement is whether or not the information is true or false, or if it is fact or opinion. The statement needs to be told to someone else. In this particular case, the statement was told to the public via a newspaper publication. Sullivan was a public figure, which is another element of defamation case per se, if the statements are about a public figure. It is only considered defamation if statement was made with the person knowing it was false. In this case, New York Times had to know the statements were true. The courts were not required to prove this in the state of Alabama. L.B. Sullivan filed a libel claim against the New York Times newspaper for an advertisement that was released in their newspaper. Sullivan was the Montgomery City Commissioner, and while his name was not directly mentioned in the ad, Sullivan claimed that the statements made could only be directed towards him, as he took the responsibility of governing the police force. Defamatory per se was filed in the case of Sullivan versus the New York Times because the ad displayed that Sullivan was incompetent at his job. Since Sullivan was the city commissioner who oversaw the police department, the false facts misrepresented Sullivan. Sullivan claimed false statements directly reflected his position as city commissioner. Since Sullivan was a public figure, he did not have to prove malice. The jury sided in favor of Sullivan. Supreme Court agrees with the jury and orders the New York Times to pay Sullivan $500,000. As I said, because he is a public figure, malice does not need to be proven. The only thing that needs to be proven is that the statements were false because he was a public figure. Gertz versus Welch. Gertz was an attorney hired by the Nuccio family to represent them in a civil lawsuit regarding the charges of murder against police officer Nuccio. Robert Welch was the publisher of a magazine called The American Opinion. Petitioner Gertz was an attorney but was not considered a public official. He did file the libel claim stating he was a public figure and won, though. The defamatory statements in the article printed in The American Opinion painted Gertz as a communist and mentioned his affiliation with communist groups in the past. Originally, Gertz won the case and was granted $50,000. Welch filed a counterclaim, and upon appeal, the decision of the lower court was reversed because Gertz was not, in fact, a private person, as he did not work for the government in any capacity and he was not a celebrity. New York versus Sullivan ruling could not be used because Gertz was a private person. This meant that Gertz had to be able to prove that the statements were made knowing that they were false, and that Welch had intentions to harm Gertz with these statements. The Supreme Court justices ruled in this case that the actual malice ruling does not apply to private individuals. Here were a few problems with this case. Welch, the publisher of the magazine American Opinion, did not confirm the story that he printed in his magazine. I am certain that the allegations had negative effect for Elmer Gertz. It's not a great look for a lawyer to have communist beliefs. Welch should have confirmed the accuracy of the story before putting it to print. After fact-checking, Welch may have had a completely different story that would not had involved a defamation case. Welch also could have reached out to Gertz for an interview and received input from him to debunk or verify what he had already discovered. Taking the time to confirm the story would have avoided this libel case. In order to file a defamation case in the state of Tennessee, the statement must be false. The statement also must have caused harm. The statement made must be about the plaintiff, and the statement must have been said or printed with the intent of malice. Tennessee must also follow the federal guidelines for defamation cases.